So the treaty only applies if the insurance premiums are not reinsured. If the premiums are reinsured to a non-qualifying reinsurer, it's important to keep in mind that it's the initial transaction that doesn't qualify for treaty protection. We're going to be talking about the cascading FET, and it does get a little confusing, but just remember that the treaty, the reinsurance out the back, then breaks the FET waiver on the first leg. But one point on this that often comes into play, and it's really fairly unclear, is that in that situation, how do you calculate how much FET is due? If you look at the treaties themselves, they seem to think about a scenario in which literally premiums are ceded from the US to the qualifying entity and then straight reinsured to a non-qualifying reinsurer. That's really the way the treaty language is drafted. But in reality, there's a lot of other types of possibilities. For example, you could have a situation where the qualifying reinsurer has a quota share with a U.S. insurer. It assumes premiums in, and then it has some type of excess of loss arrangement where some portion of its premiums are then reinsured out. And that might be on its entire book, which may include some premiums from the U.S. as well as other premiums from Europe or other parts of the world. The treaties are not really as clear as they ought to be as to how to calculate that FET when the two legs of the transaction are really not back to back, and that's something that gives rise to some problems as well as some potential solutions. Okay. So now on to the cascading excise tax. The IRS's view, as we started out with before, is that any transaction related to U.S. risk is subject to U.S. FET, even if there was an initial leg that was already subject to the FET. And as I think Mike alluded to before, this had been the IRS's position. It was always there for quite some time. They had litigated it in some old cases, but it was really not a position that was taken, frankly, very seriously. And then in March 2008, the IRS released a revenue ruling in which they announced that they would be enforcing the cascading federal excise tax, and that they really kind of affirmed the view of the service that this was in fact the correct statement of the law. One point that I would like to make, though, is that a revenue ruling, sometimes people look at revenue rulings and they think that they are statements of United States law, and they are not. The revenue ruling is a declaration by the Internal Revenue Service of its view of an uncertain position of U.S. tax law, and in court, a revenue ruling has no standing or authority at all. It's something that an individual or a company, as a practical matter, can rely on, because if the IRS says, this is what we think the law is, then you can rely on the fact, to the detriment of the government, that they're not going to apply the law in a different way. But when they apply a revenue ruling to the detriment of the taxpayer, it really has no legal force at all, other than letting people know what the IRS thinks. At the same time, the IRS provided what they referred to as a voluntary compliance initiative, which gave approximately 6 months, under which people had an opportunity to come forward, come clean, agree that they had violated this cascading federal excise tax and had not paid taxes that were due. And it really went over like a lead balloon. Very, very few people, in my experience, very, very few people thought that the terms of the voluntary compliance initiative were really advantageous. And I think for the most part, it was pretty widely ignored. And yeah, I would say through the course of 2008 and even through 2009, basically the response you got in most circles when you talked about cascading federal excise tax was, well, it's great that the IRS thinks this, or it's bad that the IRS thinks it, but it's sort of irrelevant because they're not really going to have any way to enforce it. It's really just an unenforceable position. So let's, at this stage, if we could just go back and kind of recapitulate a little bit just to make sure that we're all on the same page as to how this works. Let's say you have company A, which is a U.S. company, I should have said that, and it buys insurance from insurer X, which is located in Ireland, and let's assume for the purpose of this example that X is eligible for the FET waiver under the tax treaty between the United States and Ireland. And then insurer X is then going to go ahead and reinsure the premium to a reinsurer Y, which is located in Bermuda, which obviously Bermuda does not have a tax treaty with the United States. So under the IRS's view of the world, the insurance is subject to the 4% excise tax. The reason is that when it was initially put into place, it benefited from the treaty waiver. However, by virtue of the fact that the insurer then reinsured the premium to a non-qualifying reinsurer, that FET waiver that initially had been in effect is invalid, is voided, so that the insurance is subject to the 4% tax. In addition, and this is really where the cascade comes into effect, the reinsurance is itself subject to a 1% FET because it's an example of one entity, insurer X, buying reinsurance from another entity, reinsurer Y, in a transaction which does not qualify for treaty protection. So in this transaction, A to X to Y, under the IRS's view, there would be 5% tax that would be due to the United States. And technically, as an initial matter, A would have to pay 4% and X would have to pay 1%, although as we'll see, the issue of who has to pay FET is a little bit fuzzier than one might like. So.
Sorry to interrupt.
Sure.
But I mean, if the reinsurance company is buying reinsurance.
I'm sorry?
If the reinsurance company is being reinsured, what's happening?
Then there'd be another 1% due on that. So if Y then goes to...
Yeah, but who's going to pay? Because the insurer doesn't know that the reinsurance company is going to be reinsured.
It would be the reinsurer Y who would, reinsurer Y then goes ahead and buys retrocedes to reinsurer Z, then Y would have to pay another 1% on its retrocession out to Z, assuming Z is not qualifying under a separate treaty. And then if Z went to double A and double B, et cetera, potentially there would be potentially an infinite number of taxes due on the same, sort of like a reinsurance spiral. Yeah. Which is why nobody thought it made a whole lot of sense. I mean, I'm not I'm not defending the intellectual integrity of the argument. I'm just putting it out there. So as I said, when this first came out, frankly, I don't think anybody really took it seriously. They worried about it, but nobody really complied. In my experience, most people did not comply and did not report. And now really what we've seen is over the past, I would say, 12 to 18 months, is a very, very significant upsurge in the amount of enforcement activity. And it really relates to two directions. One is information document requests, and the other is notices of deficiency. And the information document requests, frankly, IDRs are the basic instrument of the IRS examination process within the United States. If I'm sitting in my home in New York City and I open up my mail, I may one day find an information document request from the IRS asking me to ship them over all of my bank account statements for the year 2010. So an information document request is a basic tool of the IRS. One of the things that's interesting about it is that they've asked for really a lot of information from the reinsurers. They've asked for the amounts and sources of insurance premiums and reinsurance coming in both directions. They've asked for the ceded and for the assumed. And I think one of the interesting things that raises is why are they, a lot of clients say to me, I understand why they're asking for information about the premiums that I cede because that's technically what I would be liable, what that person would be liable for is the reinsurance that they cede outward potentially to non-qualifying reinsurers. But they ask, why is the IRS asking me for information about who I assumed from? And I think it's an interesting question. I think to a large extent they're fishing for information and they're trying to put together a better picture. I've spoken to the people who are working in this area, and they freely admit that it's not an area in which they have a lot of experience. They don't really know their way around the industry. They're not that familiar with how the industry works. And I think to a large extent they're just looking to develop a knowledge base. And one of the ways to develop a knowledge base is to just ask for more information and see what you get. One possibility is that what they are trying to do is monitor compliance by insurance companies within the United States and to see whether or not, in fact, the seeding companies or the insureds, in the case of corporates, are in fact paying the FET, step one, when a U.S. person just buys insurance or buys reinsurance outside the U.S., whether or not the FET is being paid, whether or not the reports are being paid, all that stuff. So there may actually be an attempt to come up with some kind of matching system where what they're going to do is try to gather up the information that they get in response to the IDRs, gather that up from what they get from outside the U.S. from the industry, and match that up with the FET payments that are coming from within the U.S. But it's almost a guess as to what it is that they're actually looking for, and I frankly don't even know that they really know for sure themselves yet. I think to a large extent they're just trying to gather information and see what they come up with. Okay. There's a couple of other excise tax issues that I'd like to go through. It's not clear to me what specific relationship they have with the topics that we're discussing more directly today, but they're things that are sort of kind of nice to know, because they're kind of obscure little facts about federal excise tax that are, I think, important when people outside the United States are trying to make decisions as to what type of response is appropriate. And every so often when you drop them into the conversation, people say, I didn't really know that. So the first is the rule about the statute of limitations. The United States has a body of law governing the statute of limitations on the assessment of taxes, which applies to excise taxes as well. Typically, a tax can only be assessed within 3 years of the filing of the return. So once you file a return, the Internal Revenue Service has 3 years in which to examine it, review it, etc. At the end of the 3 years from the receipt of the return, they've lost their opportunity. But that statute does not begin to run until the return is filed. So that as a technical matter, if no return is filed, that statute never runs, and the IRS can, in theory, go back an unlimited amount of years and think about assessing tax, asking for information about it. So when people are trying to decide whether or not a return should be filed, an important consideration is the fact that if you do file a return, you do trigger the beginning of the running of the statute of the limitations, and that 3 years after the return is filed, you can at least rest easy that the IRS no longer has an opportunity to assess additional taxes. One of the critical issues that comes up in the federal excise tax world is, because we're talking about this cascading issue, well, whose return starts the running of the statute? In the example that we just discussed before, where we went from the insured to Ireland to Bermuda, if Ireland files a Form 720 reporting its taxes, its outbound taxes, how far down the chain is the statute triggered?